Substantial aggravation is what I would consider a somewhat aggravating standard under Ohio law. I'm going to try to give you a broad overview of how we got to this place and when the law changed and what it currently means. So this is a general overview of the presentation. I will briefly go through the history of aggravation and substantial aggravation claims just so that you have a perspective. It's important for you to understand that the way the commission views substantial aggravation and the way the courts view substantial aggravation is a little bit different. So we will talk about both of those as well. For those of you who are very sophisticated in workers' comp, you also understand that when the law changed back in 2006, there were actually two sections of the statute that were amended. 4123.01, which sets forth the definitions of injuries, but also 4123.54, which allows either the Bureau of Workers' Compensation or the employer to stop the payment of compensation or benefits when a condition that was substantially aggravated returns to the level that it would have been without the injury. And so we'll talk a little bit about the return to pre-injury status, how this statute and this concept of substantial aggravation applies to Psych claims, because I think there is a tendency that when we get a motion for substantial aggravation of a Psych claim, that it is the same sort of standard equation that we may apply when we're dealing with a physical condition. And what I'll point out to you through the language of the statute is that this is a totally different analysis, one that you have to give some considerable thought to. And then I'll try to give you some guidance, some takeaways, so that after the webinar, you just know where you want to go on all of these claims. So if you look at this graphic, before, and I'm talking like 30, 35 years ago, where aggravations were concerned, the road was pretty clear. You had a nice clear sky, a couple of clouds, but a nice sunny day. Everything seemed fine in that defense counsel, for the most part, understood that in order to participate for an aggravation condition, that there had to be a substantial aggravation. This is the way these things got litigated in the Industrial Commission over 30 years ago. But that's not how the claimant's bar saw it. And as is often the case in workers' comp, just because practitioners see the world one way doesn't necessarily mean that's the way the world should be. And around 1990, a case named Shell versus Globe Trucking came before the Ohio Supreme Court, which redefined what aggravation was for workers' comp practitioners. Basically, in the Shell case, Shell, which was a claimant represented by Gallon and Tackett, which a lot of you are familiar with, filed a claim for aggravation of a pre-existing condition. The claim went before the Industrial Commission, which denied the claim on the grounds that there was not evidence that the aggravation was substantial. So Shell appealed the disallowance of the claim to the Common Pleas Court. And in the Common Pleas Court, basically entered a judgment in favor of Shell, finding that the statute did not require that there was any significance to the aggravation. It didn't have to be measurable in any way. It just had to be an aggravation or a worsening of the condition. The Bureau of Workers' Compensation appealed this to the Court of Appeals and then ultimately to the Supreme Court. Because there was another Court of Appeals in a different district that held a different view on substantial aggravation, the Supreme Court took the case on a conflict. meaning that two courts of appeals saw the same set of facts essentially differently and came out to a different legal conclusion. When the Supreme Court got it, the Supreme Court affirmed what the Court of Appeals had done and what the trial court had done before that. And the Supreme Court said there is nothing about 4123.01 that requires that the aggravation be measurable in any particular way. It doesn't have to rise to any particular level. It simply has to be a worsening of the condition, which obviously would be demonstrated through the production of evidence. The court went on to say that if the legislature had intended for aggravation to be substantial, then the legislature needs to write that into the law. And then lo and behold, 25, 26 years later, we get that law. And up until this point, employers and the Bureau of Workers' Compensation were aggravated, for lack of a better way of saying it, by these aggravation claims, because all the claimant had to do was show that there was some worsening, and that worsening could be demonstrated by subjective complaints. And so it became a very easy avenue for claimants to get claims allowed. The problem with an aggravation claim prior to the change in the law back in 2006 was that these claims would last forever. So for a self-insured employer, they could be living with an aggravation claim until the end of time or until such time as the self-insured employer is able to ultimately get the claim settled. State fund employers obviously only had to live with it for 5 years, but it stayed with the Bureau until the Bureau was able to accomplish the same thing that a self-insured employer would accomplish, which is trying to settle the claim. And these became very, very expensive claims because when you have a condition that's aggravated, usually you're talking about something that's degenerative in nature. They're only going to get worse. So the legislature decided to address this in and around 2004, 2005, and eventually the law went into effect in 2006. So the place to start with substantial aggravation is the definition of injury. Under 4123.01, it defines injury as basically any injury. But then there's a section of the statute that talks about what's not included as an injury. And this is where we find substantial aggravation. The statute reads, injury does not include a condition that pre-existed an injury unless that pre-existing condition is substantially aggravated by the injury. Such a substantial aggravation must be documented by objective diagnostic findings, objective clinical findings, or objective test results. Subjective complaints may be evidence of such a substantial aggravation. However, subjective complaints without objective diagnostic findings, objective clinical findings, or objective test results are insufficient to substantiate a substantial aggravation. Now, this language is very, very critical for us to take a look at, and I highlighted or underlined key sections of that statutory language. Again, we're talking about something measurable, so the statute itself uses the word substantial aggravation. It also talks about how the aggravation must be documented by objective findings. And we get into a little bit of debate with opposing counsel and the courts in terms of what is objective, what kinds of findings are objective. But I want you to keep these principles in mind because they're going to be relevant to the entire presentation here. And then also the relevance of subjective complaints, because the statute did not completely eliminate evidence of subjective complaints. Subjective complaints are still relevant, but they have to be in context with the objective findings as well. So the statute sought to eliminate what happened after that Shell decision, which allowed subjective complaints to carry the day and basically govern the decision on substantial aggravation or aggravation claims. So here's a quick way to kind of think about it. Substantial basically means of some considerable degree. It's got to be measurable. It's got to be something. Somebody can't just say, I don't feel as good as I did yesterday. It has to be significant. And then there's got to be a worsening. When people think about substantial aggravation, the words of the statute are important. Aggravation essentially means a worsening of the condition. So that means some kind of way that condition changed. And then the objective evidence must show the worsening. Not everybody, including the courts of appeals, have really examined what's meant by the objective evidence showing a worsening. I want you to keep this in mind because I'll continue to hearken back to this in the statute, that it's not just a matter of having objective findings. Having objective findings in a vacuum just simply shows that you've got some objective evidence that demonstrates that a condition exists. But the way the statute's written, it talks about the objective evidence must document the substantial aggravation, meaning that it must demonstrate that a worsening took place, and that's important. And then finally, that's how you get to substantial aggravation. So again, something to keep in mind, because a lot of people will ask me, and a lot of people thought when this statute was enacted, that if the claimant didn't have any prior evidence, any prior x-rays or MRIs to compare to the x-rays or MRIs that were taken after the injury occurred, that would somehow negate or diminish their ability to proceed with a substantial aggravation claim. The reality is, though, that you do not need prior objective evidence in order to prevail as a claimant on a substantial aggravation claim. There are certain conditions that doctors can attest existed prior to the injury based on their own experience. So, for example, arthritis is a medical condition that begins in most people's bodies really in the third decade of life. So in your 20s, we all start to develop arthritis, and it continues to worsen over the course of our lives. Most of us don't really feel arthritis in our bodies or have symptoms until much later in our lives, maybe the third, fourth, or even fifth decades. But that doesn't mean that the arthritis wasn't there. It does not just pop up immediately with an injury, and it doesn't pop up within, let's say 3 to 6 months. So if you have a claim where there's a substantial aggravation of pre-existing osteoarthritis, you'd be hard-pressed to make the argument that the claimant didn't have osteoarthritis before the injury simply because there's no diagnostic testing showing osteoarthritis before that injury, or a diagnostic test that took place before that, because osteoarthritis takes years to develop. And every doctor who is going to put on a statement of causation in these claims is going to be able to say, and they will say, that the osteoarthritis pre-existed the injury because it takes years to occur. And so you don't need prior objective evidence with every condition. It may be necessary depending on the kind of condition you're talking about, but that's what you have to keep in mind, is that it's really fact-specific. Degenerative conditions, for the most part, they don't occur overnight. And if you have post-injury diagnostics, I'm sure that a doctor is going to be able to opine that it pre-existed. And at least the claimant is then over that hurdle. At that point, they're at the next step, at the next step, which is to show that there was a worsening, substantial worsening of the condition. So again, substantial aggravation means substantial worsening, means the condition got worse. So as I mentioned at the outset, the way the commission sees the world and the way the courts see the world is not exactly the same. Most of you, I can tell, are either third-party administrators or employers who have a significant hand in the management of your workers' compensation claims. So you understand that an allowance issue, which is what substantial aggravation is, oftentimes does not end in front of the Industrial Commission of Ohio. And you can't be of the mindset that once you prevail in the Industrial Commission based on the standards that were applied by the Industrial Commission, that you're going to have the same success when you get into common pleas court. Because what I'm going to show you is that the courts view this issue differently than the Industrial Commission does. So the Industrial Commission essentially has announced its policy on substantial aggravation in two policy memos, D2 and S11. You can find these in the adjudications before the Industrial Commission. It used to be known as the Hearing Officer Manual. I still refer to it as the Hearing Officer Manual because that just makes more sense in my brain. But those are the two places where the policy of the commission is announced. And so under B2, and I'm going to bring up a couple bullet points here. The commission is looking for evidence documenting substantial aggravation, which is what the statute says, objective clinical findings, or objective test results. They basically have rewritten the standard of the statute into their policy memo, okay? They go on to state in this policy memo that the determination of substantial aggravation is a legal determination. It's not a medical determination. And here is the place where the Industrial Commission and the courts go in different directions, because the Ohio courts do not see substantial aggravation as a legal determination. The courts see it as a fact issue. And so it is a medical determination according to the courts. What this means for you in the agency is that because substantial aggravation is a legal determination, that means that those of you who have hearing representatives from the third-party administrator are not going to want them to take the hearings on a substantial aggravation claim, because the Industrial Commission, through its other policies on the unauthorized practice of law, has found that third-party administrators are not allowed to make legal arguments. And so if the argument here on substantial aggravation is a legal argument, then only lawyers can handle these claims in the agency in front of the hearing officers of the commission. So you need to keep that in mind, that when you get a substantial aggravation claim, you're going to have to retain counsel, and you're probably going to want to retain counsel to get proper representation. The last thing that comes out of the policy memo of significance is that it's not really necessary for the evidence supporting substantial aggravation to contain an opinion that says, I opine that this condition was substantially aggravated by the injury. The hearing officers, because it is a medical determination, or a legal determination, they're going to look at all the evidence, and they're going to make a determination based on the evidence whether or not there is evidence of substantial aggravation or not. The fact that a doctor may not use certain terminology is not going to affect the hearing officer's decision. The other thing to keep in mind is that under Policy Memo S11, the hearing officers are allowed to entertain either substantial aggravation or direct causation of the condition when they are addressing the medical condition. Bear in mind, when we're talking about substantial aggravation of a condition, and let's use degenerative disc disease as our example, under Ohio workers' compensation law, claimants participate for medical conditions. So you would be participating as a claimant for degenerative disc disease. Substantial aggravation does not change the condition. It is not a substantial aggravation condition, so to speak. Okay? The condition remains degenerative disc disease. Substantial aggravation is merely the theory of recovery. There's this Ohio Supreme Court case called Starkey versus Builders something or other. I can't remember the exact citation, but it's the Starkey case that found that aggravation and direct causation are merely theories of recovery. And because that's a theory of recovery, the claimant merely has to demonstrate that there is proximate causation as to the medical condition. Whether they pursue it on a substantial aggravation basis or direct causation is up to the claimant. And it's up to the trier of fact to figure that out. And that's what Memo S11 basically stands for, is that the hearing officer can entertain both theories. And they may, claimant may come into the hearing room and they may have moved for substantial aggravation of a condition, and the hearing officer might just allow the claim for the condition itself. So you need to be prepared for that as well, which is another reason that you need to have an attorney present, because the theory can change. You need somebody that's got the diversity and the training in order to address both theories in the hearing room. So as I said, it's a legal determination. No magic words are necessary. As I said, the doctor does not need to use the words substantial aggravation. They could say significant aggravation. They can say a measurable aggravation. They could just say aggravation. They don't have to use any of those words. We, as your representatives, can make an argument, but ultimately what the hearing officer is going to be doing is looking at that medical evidence. And they're going to be looking at the objective evidence and the clinical findings as well to see whether or not this condition was aggravated to some measurable degree. No magic words are necessary. Since we've been following these kinds of conditions over the last several years, and it's been 12 years, which is amazing to me because it seemed like just yesterday the statute changed. But in these last 12 years, the trend that we have found is that there are fewer aggravation claims than there were prior to the change in the law. What happens, it seems, at least in the Industrial Commission, you're probably going to have better success defending these things at that level. And practitioners tend to know that because of the way in which the commission views the world. And so what a lot of practitioners will do, claimants, lawyers will do to get claims allowed is to pursue a different kind of theory. Either they're going to pursue it as a flow-through or a residual condition, or they're going to go based on direct causation because it's a little simpler. So you just need to keep that in mind, that the substantial aggravation issue, while making it more difficult administratively, doesn't mean that you're going to see a reduction in claims. You're just going to see a difference in the way that the claims are prosecuted in order to get them allowed by the claimant's counsel. As I said, you need objective findings. So by objective findings, a lot of us think in terms of X-rays or MRIs or a CAT scan. Somebody just asked the question, what if the physician of record uses exacerbation? Again, exacerbation It's just a word. And because the commission doesn't require any magic words, and the courts pretty much see it the same way too, it doesn't matter whether the doctor calls it an exacerbation. What you need to look at, though, is the substance of the doctor's report. If what he is talking about is a flare-up of a condition, if that's what he really means, then the argument can be made that this is not a worsening of the condition. So we go back to what is meant by aggravation. Exacerbations tend to be flare-ups, but doctors are not lawyers. They are imprecise with their words, and so you have to get at the heart of what that doctor actually meant if he or she used that word in a medical report or in an opinion on causation trying to support the claim. Back to objective findings, we tend to think in terms of x-rays, MRIs, CTs. Objective findings, though, are a little bit more expansive than that. You can look at an MRI, and in the MRI, you could see an uptake of fluid. That fluid collection could be an objective finding. It was found on the MRI, and that's what demonstrates the fact that it is actually there. Doctors can draw a conclusion that if someone has a diagnostic test close on the heels of an injury, and they see the pooling of fluid or blood, or some hypertrophic kind of situation, that they may look at that and say, you know, I think this is a result of the injury. This pooling of fluid demonstrates that that pre-existing condition, let's say it's the degenerative disc disease, actually got worse because the pooling of fluid then causes stenosis in the spine, which then causes the claimant to have greater symptoms going down their legs into their toes or their calves or whatever the case may be. So when you're looking at objective findings, you really have to look hard at the findings that the radiologist might make in the test, not just looking for words that this person's condition got worse. The other thing is range of motion tests and other kinds of clinical tests have also been determined to be objective in nature. They're sort of a hybrid because range of motion depends on somebody's effort, but doctors do use them as an objective test as well. So it gets a little bit tricky, and it's no slam dunk if there's no, let's say, there is no x-ray, there is no MRI, and you're thinking, wow, I'm going to win this claim on my defense. But if the treating doctor is using range of motion testing or pinpricks or something like that to determine a diagnosis, that might be sufficient objective evidence. Again, we talked about it's not necessary for pre-injury diagnostic studies. It may be necessary depending on the medical condition. And then again, the subjective complaints without objective findings are not going to be sufficient to carry the day. They have to be in the presence of objective findings demonstrating a worsening. So in the last 12 years, there probably have been around 20 or 25 cases that have made it up to the courts of appeals that have addressed substantial aggravation in one way, shape, or form. This pie chart shows 16 of those cases because these cases actually dealt with the issue directly. A lot of times they don't deal directly with the issue, or they're able to avoid substantial aggravation as an issue by ruling on the case in some other manner. But 16 courts, by my count, have actually looked at the situation. And by this pie chart, you'll see that the majority of the courts have actually supported the defense. They've upheld they've denied substantial aggravation. And 6 of those cases have either upheld substantial aggravation, 7 of those cases have either upheld substantial aggravation or remanded it for further proceedings, which basically meant that they reversed a trial court decision that found that the claimant did not sustain the burden of proof on substantial aggravation and sent it back to the trial court for further proceedings. So the courts are essentially split. Half of them think that substantial aggravation should have been denied. The other half think that substantial aggravation either should have proceeded to a jury or the condition should have been granted to the claimant. And then you have 2 other courts that disposed of the issue some other kind of way. I show you this because it gives you sort of a hard factual way of looking at the courts, and basically stands for the proposition that when you get to court, it is a coin toss. The courts are split right down the middle. I can tell you from reviewing the cases that whether or not substantial aggravation prevails as a theory always depends on what the doctors say. It is always a factual medical situation. None of these courts have rendered the decision on substantial aggravation by digging deep into the statute or the meanings of the words of the statute and rendering a decision that the claimant failed to meet the statutory burden. What they have found is that the claimant either didn't have sufficient medical evidence or that the claimant did have sufficient medical evidence. So on those cases that denied substantial aggravation, they were denied because either 1, there wasn't evidence that the condition pre-existed, or 2, the doctor didn't supply sufficient medical causation on substantial aggravation. The other cases, and most times they come up in the summary judgment context. For those of you that have been in litigation, you understand that we can dispose of cases before they get to trial by arguing that there is a legal issue, that all the facts, that there's no issue as to the facts, but because there's a legal issue, the court should dispose of it. And perhaps because the Industrial Commission has trained us all to believe that substantial aggravation is a legal issue, we file these motions for summary judgment, trying to capture the attention of the judges and trying to get the judges to rule on these things before they go to a trial. And we do that for a number of reasons, one of which is it makes the litigation much less expensive for the employers that we're defending. However, when the courts get these, at least half the courts are saying this is not a legal determination. They're saying it's a fact question. As long as there's a doctor who is going to testify that there's some evidence of substantial aggravation, as long as there's a doctor who testifies that there's objective evidence, and it's not necessarily objective evidence of the worsening, but simply objective evidence of the condition, courts are allowing it to go to a jury. And that's why, as I said at the outset, you may have success in the agency. That is not the end of the road for you on substantial aggravation claims. Smart claimants counsel are going to appeal these things into court. And you may prevail before a trial court on a summary judgment motion. That does not mean that you're going to have final success there either. If the claimant's counsel is aggressive enough and if they have the resources, they'll challenge that decision to the Court of Appeals, and that's where it gets awfully, awfully messy. So here are the principles again. These are all decided on the strength of the evidence. No court has applied statutory construction, and no court has required pre-injury documentation. There was one case that came out early, I think it was the Smith decision that came out of the 6th District. People thought that case stood for that proposition that you needed prior evidence. But that's not what the Smith case really stood for. That was a very peculiar condition. And because it was a peculiar condition, the court was not convinced that the claimant actually had that condition until there was an injury. So you have to, again, look very closely at the condition you're talking about. All right. I want to get back to the language of the statute again, because I want you to take a hard look at what it means by objective evidence of substantial aggravation. When you think about that definition. Prior to this law being enacted, when it was first introduced, the Legislative Services Commission put together what's known as a bill analysis. That bill analysis told everybody what the law was trying to accomplish, okay? And so they put together this summary, and in the bill analysis, it said, the workers' compensation law currently defines injury to include any injury, whether caused by external accidental means or accidental in character and result, that was received in the course of and arising out of the injured employee's employment. This bill expands the definition of injury to include a condition, impairment, or disease that pre-existed an injury if that pre-existing condition or impairment is substantially worsened. So again, aggravation means worsening. Or the disease process is substantially accelerated by the injury, and here's the important part, and is documented by objective clinical findings and test results. If the worsening or acceleration is not documented by objective diagnostic findings and test results, the condition, the impairment, or the disease process is excluded from the definition of injury. What they were trying to communicate when they first wrote this law, and originally the law used the word substantial worsening. It didn't use the word substantial aggravation. It got revised to include that language. When you're talking about the objective evidence itself under the statute must show the worsening. Again, the objective evidence must show the worsening. Why is this significant? Those of you who have been in the hearing room or have been in court on these cases know that claimant's counsel will simply point to an MRI, and the MRI finding might be degenerative disc disease, or claimant has stenosis at L4-5 or something like that. That objective evidence by itself merely shows you that the person has, or the claimant has, a particular condition. That's all it shows. The question is, does that objective evidence show that the condition got worse? And so when I talked a little bit earlier about some additional findings on an MRI, like the pooling of blood or fluid, something along those lines, something that shows that there's inflammation like hypertrophy, that maybe a radiologist is saying, hey, that's new. That hypertrophy is there because there was an injury. I can tell by looking at this diagnostic that injury caused this reaction in the body. That would be objective evidence that documents substantial aggravation. The problem is that most hearing officers and most of the judges and the courts of appeals have not examined the language closely enough to require that. There's only one court of appeals that has, and that is a court of appeals down in the 1st District. The case is called Salyers, S-A-L-Y-E-R-S. It came out maybe a couple of years ago. And that court basically said, in that case, the claimant has put forth objective evidence, yes, but all the objective evidence tells us is that they merely had the condition. That objective evidence by itself doesn't tell us whether or not the condition got worse. And so that claimant in the Salyers case didn't carry their burden under the statute according to the court. Now, maybe they would have been able to prevail if they had a doctor who testified and said, well, I looked at that MRI And it's this finding in the MRI that shows me that this condition now is worse off than it was before because I see these other factors. That probably would have carried the day. But the mere fact that there is an MRI showing the condition isn't enough to justify it. And that's where unfortunately, a lot of the judges aren't really looking hard enough at the language. They don't understand when the statute references objective findings, it's not just the mere presence of the findings. The objective evidence is supposed to document a change, a worsening in the condition. Unfortunately, the Supreme Court hasn't addressed this issue yet. These things oftentimes don't work their way up to the Supreme Court for a long time. And the Supreme Court's only going to address an issue like this if there's a conflict in the Court of Appeals or on a discretionary basis. Now, they're not going to see this issue in a conflict situation, I can assure you that. And the reason that they're not is that all the courts of appeals, are looking at these cases on a case-by-case factual basis. So the Supreme Court is never going to get two cases that have substantially similar fact situations, and all they have to do is look at how the law got applied. That's not going to happen. So what this means is that the Supreme Court would have to take it in its discretionary jurisdiction. And the Supreme Court rarely takes cases in its discretionary jurisdiction. If somebody's challenging the statute, though, and how the statute is written or being applied, they may be able to persuade the Supreme Court to take the issue. But most times, unless you have a very aggressive employer, most employers don't want to spend the money to go that far. So it may be a while, if ever, before we see the Supreme Court actually dig into the language of the statute. So let's talk about what a substantial aggravation of pre-existing condition looks like. We put together this graph basically to show you the progression of a pre-existing condition. If it's arthritis, you know that arthritis only gets worse. It may stagnate at some point, but the condition is never going to get better. And so if you have impairment from a pre-existing condition, it's going to, for the most part, continue to get worse and progress in severity. That's the natural progression. The reason we talk about this is because under 4123.54G, you can stop the benefits and compensation in a claim if that condition returns to what's known as its pre-injury status. Some people refer to it as return to baseline. And basically what it means is that the condition that got aggravated by the injury goes back to the same progression that it would have been on if the injury had not existed. And that's how the statute reads. So if the substantial aggravation is documented and it returns to a level that would have existed without the injury, you can stop the benefits and the compensation. So this next chart shows you what happens when there's an aggravation to a condition that pre-existed. The dotted line shows you the natural progression. We just went over that. This spike here is what happens when there's an injury and it's aggravated. So what this is trying to depict is that when someone has an injury, let's say they slip and fall, it substantially aggravates their pre-existing back arthritis. That condition gets worse. It spikes. And it's going to spike, and they're going to treat it, and they're going to get injections, or they'll get surgery, or whatever the case may be. But eventually, the condition is going to go back to the position, or hopefully it goes back to the position where it was prior to the injury occurring. And remember, early on, I said that self-insured employers and the Bureau lived with aggravation claims forever. Well, the statute was amended to stop that from happening. There's a recognition that the aggravation only lasts for a certain period of time before you get back to where you would have been beforehand. So when we're talking about return to pre-injury status, this is an underutilized tool of the employers. And I say that because we have not handled personally a whole lot of these motions. But if you have a claim for substantial aggravation, you need to file a motion after a couple of years or so to determine whether or not the condition has returned to its pre-injury status. There's not a lot of case law on this. Unfortunately, there's no real guidance in the administrative rules that support the statute. The Commission and the Bureau haven't set forth any policy memos. So it's an area that still remains a little unclear. But essentially what you're going to do is you're going to get an IME from a doctor, and you're going to ask that doctor the question whether or not the condition has returned to its pre-injury status. And you're going to compile for that doctor all the relevant information to the claim. And so all that information is going to be medical before and after, all the diagnostic tests. If you actually have the films, get the films to your doctor, not just the diagnostic reports. You're going to want to look at the treatment course. So if somebody hasn't treated for 5 years, you have a good shot at winning that motion. Whether or not they've returned to work and they're back to their normal activities, which is a situation where you may want to consider, if it's an expensive enough claim, surveilling the claimant. Because if somebody is alleging that, if someone is alleging that their condition is, really, really deteriorating, and they're out at a company picnic, dancing and playing kickball, that they may be evidence that a doctor will say, well, this condition is not as bad as they claim it is. Somebody asked the question, can an aggravation be permanent? My answer to that question is anything is possible. So yeah, there are no linear equations in medicine or in the law. It is possible that someone could have a very extended period of aggravation due to an injury. But as a workers' compensation manager, you want to do everything in your power to terminate compensation and benefits to the extent that you can. So my advice is to look closely at the claim, see if it's at a point where you might be able to fashion that kind of a motion. If you can get a doctor to explain to you why this condition is back to where it would have been otherwise, but for the injury, there's no reason not to try that in a claim that may be on your books for several years. But yes, an aggravation can be in some regards a permanent worsening that never returns to where it was prior to the aggravating event. The Bureau has a letter, so in the state fund context, they actually have a form letter, and as you may know, the Bureau and the Commission like to do things according to forms. I hate forms because they're not very flexible, but they have their substantial aggravation resolution letter that they send out, and it simply asks the question, yes or no, has the substantial aggravation condition returned to what it would have been without the injury? They send this out to the doctors to see whether or not they can terminate the compensation and benefits. I would not advise that someone send to an IME doctor something so simplistic. I think you need to ask them to provide a narrative report that explains why the condition is back to its pre-injury status. The two ways that you can get into court, 512 is an allowance. That means that you're going in front of a court of common pleas on an allowance issue. These are full-blown trials. They last 2 to 3 days, depending on the issue. Any administrative issue that deals with the allowance of the claim or the disallowance of the claim is going to be appealed by 4123-512 into the common pleas courts. Issues that deal with the extent of disability, go through a process known as writ of mandamus, which is basically an error proceeding that takes place in the 10th District Court of Appeals down in Franklin County or Columbus, Ohio. Recently, the Ohio Supreme Court determined that determinations by the Industrial Commission under 4123.54G, which deal with the termination of compensation and benefits under the statute for substantial aggravation claims, they've determined that that is a mandamus issue, that does not get appealed to the common pleas court. So if you get a determination that you're dissatisfied either as the claimant or the employer, your only measure or only means of challenging that is by writ of mandamus in the 10th District. That case is called Clendenin versus Girl Scouts of Western Ohio. Basically, there was a claim for substantial aggravation, and the Bureau moved to terminate the benefits, and they were successful. So the claimant then appealed it to the common pleas court, thinking that if you've terminated my compensation and benefits, you basically disallowed my claim. I no longer have the right to participate for this substantial aggravation condition. When it was in the common pleas court, the Bureau moved to dismiss the case for lack of subject matter jurisdiction, arguing that this is a extent of disability issue, and that the only issue that's tried before a trial court is right to participate. Because the commission didn't disallow the claim for substantial aggravation of the shoulder condition, the case was not properly before the trial court. So the trial court granted the Bureau's motion. The Court of Appeals reversed it. So it shows you that judges can't agree on anything. Went up to the Ohio Supreme Court, and the Supreme Court held that in order for this decision to be appealable to the Court of Common Pleas, the commission would have had to made a finding that the pre-existing condition was not aggravated in the course of Clendenin's employment, and that the condition was therefore disallowed. No such finding was made here. Accordingly, this matter, the decision about the extent of Clendenin's disability, is not appealable to the Court of Common Pleas under 512. And so even though I cannot imagine what benefit a claimant would have for a condition that continues to give them the right to participate other than treatment and medical compensation, and when those are terminated, it seems to me that they've effectively disallowed the claim. The Supreme Court said that's not the case. The Supreme Court says there has to be an explicit finding of the Industrial Commission that the condition is disallowed in order for you to appeal it by 512. So if you get one of these decisions on your .54 motion and you're dissatisfied, you'd be going by way of mandamus. Mandamus is not as expensive as an appeal to court. However, the standard on mandamus is awfully difficult, because the standard on mandamus is whether or not the Industrial Commission abused its discretion. And the way the courts have interpreted that means as long as there is some evidence that the commission can rely upon, the courts are going to uphold the decision. Lastly, substantial aggravation of Psych claims. Don't roll on these. Again, Psych conditions like substantial aggravation conditions are included in the statute in the negative. An injury does not include a psychiatric condition except where the claimant's psychiatric conditions have arisen from an injury or occupational disease, etc. The key language is arisen from an injury. So you put on your thinking cap now. We're talking substantial aggravation of a pre-existing condition. If I have depression and it pre-existed my injury, how can that same condition have arisen from the injury? That's counterintuitive. If I have depression and it pre-existed the injury couldn't have caused it. So it couldn't have arisen from the injury. By the language of this statute, a claimant should not be able to participate for substantial aggravation of a psych condition because it didn't arise from the injury. The other thing to keep in mind is, remember, the second part of the statute on substantial aggravation talks about objective evidence supporting the substantial aggravation. What objective evidence would there be in the psychological context that would support a substantial aggravation of a depression? There aren't really any objective tests that are utilized in psychiatric or psychological care. What you have is the DSM-5 or the DSM-4, whichever version the psychologist or psychiatrist is using. And those treatises are not being used to objectively determine whether or not a condition got worse. They're guidelines used by psychiatrists and psychologists to have consistency in diagnosis. That's what they're used for. So, and if you talk to a psychiatrist or a psychologist, they'll tell you, we don't have any objective tests. Even the MMPIs and those other tests are not designed to objectively tell you whether a condition got worse or not. What they're designed to do is to tell you whether or not this person has a particular diagnosis. And so I would argue that if you get a claim for substantial aggravation of a psych condition, you have an excellent defense on two fronts. One, a psychological condition can't pre-exist an injury and also be compensable under this part of the statute. But also, there's nothing objectively that would support a substantial aggravation of a psych condition. So be mindful of that. So these takeaways, again, don't be so anxious to certify substantial aggravation claims. You might think it's a bad claim, and you may think, well, you know, it was significant. Maybe we should allow it. These are claims that you should challenge. As I said before, you need to obtain counsel because the TPA representative is not going to be able to make the arguments in the administrative level. If you get these claims and you've had them on your books for 2 or 3 years, try to get the compensation and medical stopped by utilizing your rights under 4123.54G. Make sure that when you do refer it to a doctor that you ask all the right questions, you provide them all medical, and if possible, give them the actual diagnostic studies as opposed to the reports. And perhaps in the future, the Supreme Court will give us a little guidance on this. Of course, I can be contacted at my email address, which it's at the bottom of this slide. So if you have any questions, just feel free to email me, and I'll be happy to answer them. Otherwise, I've enjoyed conducting the webinar, and we will talk to you at the next Bug Bin Conkle webinar or seminar. Thank you for your attention.